Hi everyone. So today I'm going to be talking to you about imposing state liability for abuse and neglect that occurs in foster care, whether that be imposing liability on the foster care provider themselves, the overseeing caseworker, the Department of Child and Family Services, or the state of Louisiana itself. So in an ideal world, and I truly believe that this is the case for the majority of foster care providers, they are loving and caring and truly seek to serve and provide help to children that otherwise are in the most unfortunate of circumstances. However, there are instances where these foster care providers kind of slip through the cracks and are the types of people that seek to take advantage of the system, either because of the compensation that it provides to the providers for taking in children, or because of some other, malicious type of of behavior trait that they may have. Nonetheless, there are instances where this occurs, and instances where these providers maybe shouldn't have been providers in the first place. Thus, parties seek to hold the state entity accountable for their child, their biological child, being placed with these providers in the first place. So in this presentation / my paper, what I'm really seeking to do is to point out the ways that you kind of navigate first the state's sovereign immunity, number one, and then really ways that you bring a successful cause of action against these entities, and what types of cause of action those may be. So obviously, I kind of became interested in this issue. I don't know if any of you have seen the Gabriel Hernandez documentary on Netflix, which basically chronicles a young boy who was severely abused, actually by his biological parents, but who had been investigated by social services many, many, many times over the years, and had basically slipped through the cracks, and ultimately the little boy died. But basically in that documentary, they portray the caseworkers and their ultimate criminal trials for basically negligent supervision, and basically endangering the child by failing to properly oversee the parents and the care. And it led me to kind of to think about that for a second. And unfortunately, in Louisiana, as many of us are likely familiar, many state and governmental entities are largely overburdened, especially the ones that seek to serve others, the public defender's office and DCFS in this case. And as I'll kind of go into later on, there have been several audits and reports of just how overburdened the caseworkers are. So in this case, I'm going to be talking about imposing vicarious liability for DCFS, and also kind of a direct negligence action against the caseworkers. And before I kind of get into this, I just want to say that I think so highly of the people that choose to spend their lives really aiding and trying to help these children, and dedicating more hours in the day than many of us ever will to a career to these children. However, there are instances where they're just overworked, or it's not the right person for the job, and the actions kind of can lead to some unfortunate circumstances for several children. So that's what I'm going to be kind of exploring here and explaining to you all. So basically, I'm going to go into some statistics of abuse that occurs in foster care. Kind of going to go into Louisiana foster care, just generally how many kids are in it, etc. And then I'll get into the the first year torts lesson as it's going to kind of be, and then kind of try to resolve some issues at the end. So first I want to touch on the Louisiana foster care kind of by the numbers. Right now there are roughly 4,700 children per month in foster care in Louisiana, with 50% of those being under 5 years old. Last year there were just over 7,000 children served in foster care, with 159 of those being in the new extended foster care legislation, which provides that if you are 18, where you normally would have aged out of foster care, if you satisfy certain criteria, you're allowed to stay until you are 21. So this adds a little bit to the numbers. Additionally, there were 827 new foster homes certified last year. Louisiana has a great foster care program. However, these numbers are large, and 827 new foster homes is a large number. So what I really want to highlight here is and ensure is that these providers are adequately certified, adequately credentialed, qualified, etc., in order to provide the loving and caring foster home environments that they should. So from a state-by-state basis, statistics on foster care, abuse, and neglect are relatively difficult to come by, and that could be for a various amount of reasons. Of course, states want their foster care programs to be reflected in a positive light. So it's difficult to say that type of information would be easily ascertainable to someone in the general public. So basically, what we have most available are national statistics. So the Administration for Children and Families, which is a division of the Department of Health and Human Services, every year creates a report on child maltreatment. The most recent report is the 2018 report. The 2019 report is not yet available. I assume it's kind of being compiled and will be out soon. Nonetheless, what they do is create data for the different instances of abuse and neglect, whether breaking it down by age of the child, the relationship to the perpetrator, etc. So, in the breakdown of the relationship to the perpetrator, they reflect certain categories such as parent, relative, non-parent, child care provider, foster care provider, etc. So the breakdown statistics, unfortunately, Louisiana was the only state that had zero breakdown statistics. While some states were missing certain categories, Louisiana, it was either unable to provide or doesn't collect that type of data. So nonetheless, that was not available in the report. So what we have available is the national statistics. So there were about 1,659 cases of foster care provider abuse reported, which compared to the national level of total abuse and neglect cases is about 0.3%. There's about 417,000 cases of abuse and neglect reports total. So while this does seem to be an extraordinary low percentage, lots of researchers, academics, and scholars believe that this number could be erroneous for a variety of reasons. One is a bit of administrative, in that some states are not consistent in how they categorize these abuse and neglect cases. So, for example, if you have a child who the perpetrator of their abuse and neglect is both their aunt and their foster care provider, some states will categorize that as relative abuse versus foster care abuse, which is understandable because it's tough to draw the line when someone satisfies two categories. So that's one reason that the results are potentially skewed. Another is, for example, if you have three siblings placed in a foster care home, and those three siblings each are the victim of abuse of their foster care provider, some states report that as one instance of abuse because it's one familial unit, whereas other states will report that as three instances of abuse because it's three separate children. So while these may seem a bit minor, when you're comparing that on a national scale, and each state could potentially be reporting this way, it adds up. So several academics and scholars have conducted kind of their own independent research and done some general population surveys, and they think the actual abuse numbers for foster care is about 1.4%. And that was, it's not much far off, but, they think those reasons could be attributable to the discrepancy there. Nonetheless, it does seem to be relatively low. However, that doesn't mean that it's not occurring. So as I mentioned before, it's no secret that many governmental entities in Louisiana are largely overburdened, understaffed, and overworked. So a legislative audit was conducted on DCFS for the 2012 to 2016 period and published in 2017. That report indicated that in some instances, staff of the Department of Children and Family Services failed to perform background checks on foster parents. The report also indicated a high turnover rate amongst the department's field workers. Additionally, between 2012 and 2016, there were 9 incidences where foster care providers with prior cases of abuse or neglect were permitted without getting the proper prior approval from the department head. So essentially the procedure for that is when a provider seeks to become a provider, if they have prior instances of abuse or neglect, it must be approved by the department head. In these 9 instances, none of those providers were approved properly. In one of those instances, the provider had multiple prior valid cases of abuse and neglect, yet was still allowed to serve as a foster parent and subsequently abused another foster child while in their care. There were also dozens of cases in the 2016 period where criminal background checks, which are required, were not conducted at all. So DCFS policy basically states that each caseworker can or should and can only handle 10 cases at a time. However, during the audited period, each caseworker had about 16 cases, which is, almost double the amount that they're supposed to have. And, it can be said that that's negligent or not, but unfortunately, this is kind of the state that we live in, where people have to undertake more than they're supposed to, just because of the magnitude of children that are coming through the system. But also during this time, the number of caseworkers was rapidly decreasing, and then the number of children under the jurisdiction of DCFS was rising. The intense workload seems to correlate to the quick turnover. And unfortunately, that quick turnover and the lack of stability in these children's lives, they are very accustomed to seeing the same caseworker and knowing personalities. It further disrupts their already unstable life. So obviously, this overburdened system and these high caseloads and such can lead to instances of unfortunate circumstances, and as I mentioned, people slipping through the cracks, and that audit it indicates that has happened. So that's kind of why I want to reflect on the liability here for those cases. So, before I go into the available causes of action, I have to spend some time discussing sovereign immunity, which many of you will probably remember from first year torts. So, sovereign immunity essentially is the concept that the state is immune from suits in its own courts. So, in the olden days, you could not sue the state of Louisiana unless it was determined on a case by case basis that the pursuit of that liability was available. Um, Louisiana has now waived its sovereign immunity in its constitution. So in Article 12, Section 10, Louisiana waived its sovereign immunity for contract and tort matters. So you have to plead a cause of action in one of those arenas in order for it to be waived. In other realms, it has to be authorized by the legislature, so you're just going to have to look for another little avenue. But in this case, we're talking about tort, so the sovereign immunity has been waived. Nonetheless, the waiver is governed by the Louisiana Governmental Claims Act, which is in the Louisiana Revised Statutes 135101, which basically gives the policies and procedures for pursuing a tort theory against the state. So it applies to any suit in contract or for injury to person or property against the state, a state agency, an officer or employee of the state or a state agency arising out of the discharge of his official duties or within the course and scope of his employment. So this is obviously applicable to DCFS and its caseworkers and the state of Louisiana itself, which is what we're focusing on here. Also, there is a cap of $500,000 of liability on general damages, but no cap on medical and special damages. So also, under the Governmental Claims Act, a jury trial is prohibited unless the government opts into that jury trial, which doesn't happen very often. So, I mean, if you didn't have to undergo a jury trial, I'm not sure that many people would, due to the just uncertainty behind it. So with sovereign immunity being waived, in this case, it allows you to move forward and proceed with a tort claim. So I'll be focusing on that next. The most obvious causes of action against the state, DCFS, or its caseworkers lie in the theories of either negligence or vicarious liability. So the kind of most readily available negligence claims would be a negligent supervision or a negligent hiring. Negligent supervision, obviously, kind of meaning that the DCFS failed to adequately supervise its caseworkers. Negligent hiring being DCFS hiring a caseworker that wasn't properly suited for the job in the first place. Vicarious liability is where the law kind of comes up and causes a few problems in the way that the jurisprudence has interpreted this to apply. So in a traditional vicarious liability sense, which we're all, hopefully familiar with from years past, otherwise known as respondeat superior, it is essentially imputed liability on the employer for the acts of the employee, whether they be negligent torts or intentional torts. A lot of people forget that you can impute liability to the employer for intentional torts of the employee. So this is either imputing liability for the acts of the foster care providers in their own acts of abuse, or for the negligence of the caseworkers. However, the problem, and I'll kind of highlight in the next slide when I go over the jurisprudence, the problem is the necessity in establishing an employer employee relationship, which we remember the elements of vicarious liability from first year, and you got to tick those boxes. That is the number one box that must be ticked for respondeat superior claims. So, unfortunately, the jurisprudence hasn't really touched on whether a foster care provider and DCFS constitute an employer-employee relationship. So I'll kind of highlight that, but I just wanted to first go over that these are likely the most readily available causes of action in these instances. The seminal case in Louisiana for imposition of liability against a state department is Vonner versus State through the Department of Public Welfare. So in this case, it was a 5-year-old child in the legal custody of the state that was ultimately beaten to death by his foster mother. The biological mother then brought suit against the state, and the Supreme Court ultimately found in favor of the biological mother and held that the department was vicariously liable for the torts of the foster parents as they breached the department's duty to ensure the well-being of children in its custody. So essentially what the court said is that the department was vicariously liable due to the fact that Louisiana law imposed a non-delegable duty upon the department to provide for the well-being of a child in its custody. So I'll kind of point out later the issues with that, but Miller versus Martin, a much more recent case in 2003, basically followed the precedent that Vonner set. This case was pretty much the same set of facts. Biological mother sues the state for the physical and sexual abuse perpetrated on her children during their time in foster care. The court basically found the same exact holding that once the department is granted legal custody of children in need of care, the custodial duty to the children is so great that it cannot be delegated to the foster parents. While the department may contract with foster parents, as it did in this case, it contracts with the foster care provider to care for the children in its custody, it ultimately is responsible for the protection of those children. Thus, if the foster parents fail in their own duty and abuse the children, the department is vicariously liable for those acts of the foster parents that caused a breach of the department's custodial duty. So what I really want to highlight here is the court's usage and reliance on vicarious liability. As I mentioned before, vicarious liability lies in the employer-employee relationship. The dissent in Miller versus Martin is very critical here in that it points out the lack of the court's determination that there was an employee-employer relationship between the state and the foster care provider. In fact, it didn't do that at all. Instead, what it said was that since the department's duty was non-delegable, it is vicariously liable. Now, this is not the vicarious liability that we know or that is traditionally imposed. This is not being properly utilized, seemingly, and the dissent continues to point this out. So the dissent was written by Justice Victory, and he goes into the fact that the imposition of vicarious liability was unnecessary because the court could have just have easily as found that the department was directly negligent itself. It did not have to rely on vicarious liability. And additionally, it improperly relies on this non-delegability doctrine, which has its roots in agency law and really has no substantiation in the civil code in relation to vicarious liability. So basically, it said that the majority here went outside the scope of the law and created this theory that is not true respondeat superior. So it was inappropriate, and a better realm of relief here would have been the direct suit for negligence. So the problem here, and what I really want to highlight, is that this is basically the only case which establishes liability for the state caseworkers for abuse perpetrated by a provider. So this is the only precedent in Louisiana, and it seemingly incorrectly applies tort law. So when you take it and you kind of pick it apart, it doesn't take a very long analysis to agree with the dissent and say that this is not right. So the problem here is there's too many legal theories being interrelated, and the result is ultimately flawed as a result. So that brings me to kind of the end of this presentation and just kind of what I wanted to highlight here. So thank you.